Hey class, welcome to week 2 of Environmental and All Hazards Management Law. Like last week, I'm going to break this week up into 2 separate narrated lectures. So I promise this won't be the norm. It's just that these first couple weeks of class, we have a lot of background information to cover before we can dive into specific topics. So this week, we're going to talk about the American bureaucracy. I'll do that in this part. And then in part 2, we're going to talk about agency discretion. All right, so let's get started. Oftentimes, administrative lawyers and public officials, public administrators get this question, is bureaucracy good or bad? And in reality, it's neither. A bureaucratic system is simply the most effective way that we know for managing a large organization, be that a government or a corporation. In our case, when we talk about the American bureaucracy, we are talking about non-elected government officials in the executive branch. So these can be political appointees, or they can be career civil servants, who are the people who do the day-to-day work to keep our government running. The foundation of bureaucratic management, what we call public administration, is rules. And it's just not possible to write rules that foresee every single thing that could happen. So there are times when either the bureaucrat or an entity outside of the bureaucracy, like an elected official or the courts, has to intercede in order to reach the best decision. So a properly designed bureaucracy is going to have that flexibility to handle situations that were not foreseen. And we'll discuss this a little more in part 2 of the lecture. But as you probably know already, German sociologist Max Weber argued that bureaucracy constitutes the most effective and rational way in which we can organize the human activity and the systematic processes that are necessary to maintain order, to maximize efficiency, and also, importantly, to eliminate favoritism in government, which is why we have civil service protections in place for our career bureaucrats. On the other hand, Weber also saw unfettered bureaucracy as a threat to individual freedom. There was this potential of trapping bureaucrats in an impersonal iron cage, is what Weber called it, of rule-based rational control, where basically they are just cogs in a wheel and have no discretion, and instead are kind of forced to carry out these black and white mandates, which does not do us any good. So you'll recognize this slide from last week. As I noted then, government bureaucracy is not new. The word itself, bureaucracy, was coined in the mid-18th century, but organized and consistent administrative systems existed much, much earlier. So the first such system we know is from 3500 BCE in ancient Sumer, where the development of writing and the use of documents, in the Sumerian case clay tablets, created a class of scribes. These are our first historical bureaucrats, and they were responsible for administering the harvest. And as we discussed last week, Egypt, Persia, and Rome had thriving bureaucracies long before the word was coined. So government bureaucracies are nothing new. What is somewhat new from a historical perspective is how a bureaucracy functions within a democracy. So there can be pure democracies, republics, and democratic republics. The United States is a democratic republic. We are not a pure democracy. We elect politicians to represent us rather than engaging in direct control of the government. We're simply far too big to engage in direct control. However, even though we elect representatives, the ultimate authority to govern is supposed to rest with us, the people, not with the government itself. So our government's authority is intended to be limited by our individual civil liberties, and our government is supposed to be accountable to its citizens primarily through elections, but we'll also talk about other methods of holding the government accountable. So we don't elect our civil servants, our public administrators. So the bureaucracy itself is not a democratic institution, but agencies are accountable to the people, us the public, in certain ways. So for instance, we elect the president, who appoints agency heads, and we elect members of Congress who hold the purse strings for those agencies, which is pretty important. Although the US has a bureaucracy embedded in our democratic system, bureaucracies are really value neutral. They work equally well in authoritarian regimes as they do in democratic ones. So a bureaucracy is simply a way to manage a large organization. And in the end, it's up to us, the people, to make sure that we are properly managing our bureaucracy. So let's talk a little bit about the structure of our federal government so that we really understand where the bureaucracy fits in. While the Declaration of Independence broke the American colonies away from England, it's the US Constitution that is our true founding document. And it's really important that it begins with we the people, because that shows that the government is intended to be accountable to the people. Our government does not govern pursuant to divine rights, which is how kings governed, or pursuant to anything other than the will of the people. So the US government was truly intended to be a government for the people, by the people. And although the people meant something quite different back in the 1700s, historical documents do indicate that the framers of our Constitution intended it to be a living document, not something that was stuck, back in the late 1700s, early 1800s. The Constitution is also a fairly short document, so if by chance you have not read it, please do so. I've included a link on the screen to a transcription of the Constitution provided by the National Archives. It is really important that we, as public administrators, understand the Constitution because that forms the bedrock of our jobs. So here is a chart of the structure of the US federal government. We have 3 co-equal branches of government, which are intended to provide checks and balances on each other. So very basically, the legislative branch creates the law, the executive branch carries out the law, and the judicial branch interprets the law and makes sure that the other 2 branches are not overstepping their authority. So you can see here on the lecture slide that I also have a list of agencies. The majority of these fall within the executive branch, but a handful fall within the other 2 branches. What this structure with this chart here does not represent are the states or Native American tribes, and so we'll get to those pretty soon. So the Constitution starts with the preamble, the we the people, and then it goes on to Article 1. And Article 1 creates the legislative branch. Section 1 of Article 1 states very clearly that all legislative powers are vested in Congress, and that Congress is composed of 2 houses, the House and the Senate. It is a bicameral legislature. Article 1, Section 8 sort of sets forth the whole scope of legislative powers that are granted to Congress. The first clause in Section 8 notes that Congress must provide for, quote, the common defense and general welfare, end quote, of the public. So this is why the president, for instance, cannot unilaterally declare war. The war powers are granted to Congress. Section 8 has other statements of congressional power, including regulating commerce with foreign nations, among the states, and with Indian tribes. And this phrase about regulating commerce is important for 2 reasons. It sets up Congress's Commerce Clause authority, which we'll discuss shortly, and it recognizes that the states and Indian tribes have their own sovereignty, because that clause, the Commerce Clause, puts states and tribes on equal footing with foreign nations. It's not on the lecture slide, but Section 9 of Article 1 contains some restrictions on congressional power. So it prohibits Congress from, among other things, favoring one state over another, or creating laws that are applied retroactively, which we refer to as ex post facto laws. Article 2 of the Constitution creates the executive branch, and it vests all executive power, the power to carry out laws, in the president. So the president is the commander-in-chief, the president grants pardons, appoints ambassadors, and so on. Article 2 also sets forth the process of removing a president, impeachment, which is triggered if the president engages in high crimes and misdemeanors. So that charge of high crimes and misdemeanors was understood by the framers to cover allegations of misconduct by officials. So that can include ordinary crimes, but was really intended to cover abuses of authority, regardless of criminality. And because it does so because we, the people, expect our elected officials to adhere to their oaths of office and do right by the public. So while impeachment's all over the news right now, for our purposes, the most important part of Article 2 is that it grants the president the power to appoint and oversee the principal officers in each executive department. So this is a really important point for administrative law, including environmental and emergency management laws, because policies are generally set by agencies from the top down. So here's a little bit about why that phrase is important. Each cabinet department is headed by a secretary, and the president appoints each secretary, who also has to be confirmed by the Senate. And each cabinet level department is made up of many, many, many agencies. The Department of Commerce, for example, contains the National Institutes for Standards and Technology, better known as NIST. The National Oceanic and Atmospheric Administration, or NOAA, runs the National Weather Service, which, in my opinion, NOAA is actually one of our most important agencies for the public benefit. The Census Bureau, we've got the U.S. Patent and Trademark Office. So although it's called the Department of Commerce, the department's actually prohibited from engaging in commerce. It instead serves as a major scientific and data repository for the U.S. government. There are also agencies within the Executive Office of the President, such as the Office of Management and Budget, OMB, and then there are independent agencies, including, for instance, NASA and the Environmental Protection Agency. So let's focus on the USDA for a moment, just so that you can see how much an agency really does. So on the lecture slide is the USDA's org chart. The USDA has an internal rule that limits its departments to 7 offices run by undersecretaries. So when President Trump took office, the Trump administration wanted to show that it was really serious about foreign trade, so it split one box that was formerly Farm and Foreign Agricultural Services into 2 different boxes. It wanted to separate out domestic from foreign. But in order to do that, it had to eliminate an undersecretary because the USDA is limited to 7 offices. The one to go, unfortunately, in my opinion, was rural development, the part of the federal government, particularly the USDA, that provides the most help to rural Americans. And the Rural Development Office helped rural communities develop and expand businesses, create new economic opportunities, build and maintain housing, water, electric, telecommunications, and other infrastructure. It was the most powerful advocate for rural America. In fiscal year 2016 alone, the USDA, for example, made over $29 billion with a B, $29 billion in loans, guarantees, grants, and related assistance to over 157,000 individuals, businesses, nonprofits, cooperatives, and state and local governments. So when the Trump administration went to eliminate this particular office, 578 organizations, businesses, and local governments signed a letter opposing the elimination of the Rural Development Mission Area and its undersecretary. That was to no avail. That particular office was eliminated. Now, of course, this does not mean that the USDA's Rural Development Mission disappeared. It's just now run by an assistant to the secretary who has less authority than an undersecretary. So, of course, the president is not the only one with control over the USDA. Congress has passed numerous laws that set USDA policy, and you'll see on the lecture slide a list of them from Wikipedia. Wikipedia does a surprisingly good job when it comes to administrative law, so it's perfectly fine with me if you want to use it as a starting point for your research. Just please don't cite to it. Instead, I recommend data mining the Wikipedia entries because the footnotes will often direct you to legitimate scholarly sources. In any event, based on all of these laws, the USDA issues regulations and it maintains a wide variety of operations. If you haven't read Michael Lewis's book called The Fifth Risk, I recommend it. It's a quick read, and it's a really good look at the inner workings of agencies. It's been called a love letter to the bureaucracy. So if you're in public administration, it is a good book to read. In that book, Lewis interviewed many people, including those in leadership and senior executive service in the federal government, to find out what their agencies do and to try to help the American public understand the importance of our bureaucracy. And at one point in the book, Lewis describes a drinking game played by some people who have worked at the USDA. It's called Does the USDA Do It? And in this game, somebody names an odd function of government, say shooting fireworks at Canadian geese that are too close to airport runways, and then somebody else has to guess if the USDA does it. In this case, yes, they shoot fireworks at Canadian geese. So the USDA does, of course, provide assistance to farmers, but really only a small fraction of the USDA's massive annual budget is spent on farmers. The USDA also finances and manages tons of programs in rural America, including ones like free school lunches for kids living near the poverty line. The USDA is also responsible for the safety of all of the meat that we eat, whereas the FDA is responsible for non-meat. So interestingly, cheese pizzas are the FDA's problem, but pepperoni pizzas are the USDA's problem. So that's just one of the myriad of little tidbits of information about the inner workings of our government. But as you can see from the slide, the name USDA, U.S. Department of Agriculture, is really misleading, much like the Department of Commerce's name is misleading. You would think, based on the name, that the USDA focuses on agriculture, and it does, but it also does so much more. So it runs 193 million acres of national forest and grassland. It's charged with inspecting almost all of the meat that Americans eat. That includes 9 billion, again with a B, 9 billion birds per year. The USDA runs a massive science program. It runs a bank with $220 billion in assets. It maintains a shooting range inside of its DC headquarters, where it also keeps an apiary on its roof to study bee colony collapse. The USDA sort of polices conflicts between people and animals, and it brings legal action against people who abuse animals. As I said, it provides free lunches for kids living near the poverty line. It runs SNAP, the Supplemental Nutritional Assistance Program, which we used to call food stamps. It provides a lot of assistance with disasters, from avian flu to wildfire. For instance, the USDA keeps a huge fleet of aircraft for firefighting. So it does more than all of this, but I think but this should give you a pretty good feel for the fact that the name of an agency doesn't necessarily cover everything an agency does for the public benefit. All right, getting back to the Constitution, let's take a look at the Judicial Branch, which is created by Article 3. The Supreme Court is the only court created specifically by the Constitution, but pursuant to Article 3, Congress can and has created other courts. So our district courts and courts of appeals, also called circuit courts, were created by Congress, but they fall under the authority of the Supreme Court. And Article 3 sets forth the scope of that authority. So the Supreme Court has the ultimate say when it comes to cases arising under the Constitution or federal laws, cases involving ambassadors, admiralty and maritime cases, and cases where the U.S. is a party. So the Constitution gives the Supreme Court both original and appellate jurisdiction, meaning that some cases can be filed directly with the Supreme Court, that's original jurisdiction, and others have to work their way up through the court system before the Supreme Court can hear the case, that is appellate jurisdiction. And we're going to talk about this later when we examine the concept of judicial review as a method of holding agencies accountable to the public. So Article 4 of the Constitution deals exclusively with the states. This is the article that contains our full faith and credit clause, which is basically an acknowledgement that each state must respect the laws and rulings of its sister states. Article 5 provides the process by which we can amend the Constitution. Article 6 clearly states that the Constitution is the supreme law of the land. It also requires all government officials, elected or appointed or in the civil service, to take an oath or affirmation to support the Constitution. And importantly, Article 6 prohibits religious tests for office. The framers were not a particularly religious bunch, at least not as we understand it, religion today. And they did not want to limit government service to any particular religious group. So then, after the Articles of the Constitution come the Bill of Rights, the first 10 amendments to the Constitution. And federal and state agencies must comply with the Bill of Rights, and we're going to discuss that later in the course because it is really important for public administrators. So by setting up a federal government while also recognizing the various state governments, the U.S. Constitution created a federalist system. And federalism is defined as a division of power between two sovereigns. So the Constitution sets forth the powers of the federal government as a sovereign government, but it also recognizes the sovereign rights of state governments and the rights of the people. So there are three types of federalism: dual, hierarchical, and cooperative. In dual federalism, federal and state governments are both sovereign, and they have different and sometimes concurrent jurisdiction. And in dual federalism, the federal government is limited to the powers that are actually enumerated or specified in the Constitution, and then the states and the people retain all other powers. In hierarchical federalism, the federal government is completely supreme. It claims powers, and then the states only have the powers that are not claimed by the federal government. This is not, however, entirely different from dual federalism, because dual federalism still recognizes the supremacy of federal laws over state laws, and hierarchical federalism still recognizes that the feds are not supposed to make a power grab at the expense of states. Finally, there is cooperative federalism, which is a close and collaborative relationship between the state and federal governments to carry out a common objective. So typically, this is the administration of federal programs with assistance from states, or the administration of state programs with the assistance from the feds, usually in the form of block grants. So the U.S. started out as a dual federalist system, but over time, we've become more of a hierarchical system. But even so, these forms of federalism are not entirely mutually exclusive. So in our hierarchical system, we still engage in dual and cooperative federalism. So here is a rather intricate view of our federalist system from 1862. It's a pretty beautiful diagram of how the federal government and all the states, how these governmental powers flow through the American Union. I'm going to post this in our online classroom so that you can take a closer look if you're interested. Okay, as promised, let's talk a bit about states and tribes. First, just a little note on language. Although we now use terms like Native Americans, First People, or Indigenous People, the federal government's legal term is American Indian or just plain Indian. So outside of the legal context, I personally don't refer to North America's indigenous peoples as Indians, but in the legal world, it is indeed the correct term to use. Now remember, the Constitution, in the Commerce Clause, recognizes foreign nations and Indian tribes in addition to the states. And that means that the federal government recognizes the sovereignty of Indian tribes, the same way that it recognizes the sovereignty of state governments. And the reason for this is the historical manner in which Europeans first interacted with Native Americans. So to Europeans arriving in the Americas, the tribes were pre-existing governments, and the Europeans dealt with them on a government-to-government basis. European governments would enter into treaties with Indian tribes the same way that, for instance, England would enter into treaties with France. After the American Revolution, U.S. presidents, Congress, and the Supreme Court repeatedly affirmed that tribal nations retain powers of self-government. Sadly, that's not to say that the federal government has done a good job of respecting tribal rights. I think we all have at least some insight into the history of how the U.S. government dealt with Indian tribes. Putting that history aside, even on a benign and bureaucratic level, the federal government still asserts control over Indian tribes in a way that it does not exert control over the states. There are many laws and a whole host of regulations in the Code of Federal Regulations that deal with Indian tribes. So for instance, Title 25 of the CFR, that's our Code of Federal Regulations, it sets forth regulations with which Indian tribes must comply. And there's no similar CFR title for states. Of course, states are still required to comply with various federal laws and regulations, including those related to emergency management. You can see on the lecture slide here an excerpt from the Stafford Act, which requires states to implement certain roles and responsibilities in their emergency management plans. So the U.S. Constitution, it makes certain guarantees to the states and tribes as sovereign governments, but it also expects various levels of compliance with federal laws and regulations. All of our state governments and many tribal governments are set up quite similarly to the U.S. federal government in that they have a constitution and 3 co-equal branches of government. So at the state level, the executive branch is headed by a governor. The legislative branch is called usually the General Assembly or the state legislature, and with the exception of Nebraska, these are all bicameral legislatures, so they consist of 2 houses. And then the judicial branch is home to several levels of state and tribal courts. It's actually within the state court system that we tend to see the most difference between state governments. So for New York, state of New York, for example, has a really convoluted court system where the trial courts are called Supreme Courts. Now, most states call their highest court the state Supreme Court, much like at the federal level, the U.S. Supreme Court is our highest court, but not all of them do. So New York uses Supreme Court to refer to its lowest courts, and Maryland, for instance, calls its highest court the Court of Appeals, even though Maryland, like all states, does indeed have a layer of courts, appellate courts, between the lowest courts and the high court. Tribal governments have a lot in common with state governments, and they're often set up similarly. So in tribal governments, the executive branch is headed by a governor, president, chief, or chair. The legislative branch is called the tribal council, and the judicial branch consists of tribal courts that have jurisdiction over members of the tribe. So both state and tribal governments have sovereign immunity. Technically, tribal governments are full nations, so that we've got nations within a nation, whereas states are not nations, they are simply part of a single nation. While states are sovereign governments, they do have to comply with the U.S. Constitution, federal court cases that impact constitutional rights, and a whole bevy of federal laws. That is not automatically the case for tribal governments because of the fact that they are recognized as separate nations. So for the most part, there does have to be a treaty or some other agreement in place for the federal government to force tribal governments to comply with federal law. And interestingly, Native Americans are citizens of 3 sovereign governments: their tribe, the state in which they live, and the U.S. government. So the importance of state governments is generally obvious. We're all residents of a state, and we expect that our states perform certain services. The importance of tribal governments is much less obvious to Americans who live in cities and in suburban areas. But many non-Native Americans rely on tribal government services. In many rural areas within the U.S., tribal governments are the only governmental presence for both Native and non-Native communities, and tribal governments provide vital first responder services. Back in 1975, Congress passed the Indian Self-Determination and Education Assistance Act, which increased tribal control over the administration of reservations, including infrastructure maintenance, law enforcement, and emergency response. And the federal government relies on our tribal governments to protect and serve both natives and non-natives in rural areas. Additionally, Native American tribes often play a key role in the environmental movement. So back in 1971, there was a public service announcement for the anti-litter organization Keep America Beautiful, and that starred Iron Eyes Cody as the Native American who sheds a tear when pondering pollution caused by the modern world. Now, ironically, Iron Eyes Cody was actually an Italian-American actor, and Keep America Beautiful was founded by beverage and packing companies in response to the first Earth Day. But even so, Native Americans really have led the way on many environmental issues, including things like the Standing Rock tribe protests over the Dakota Access Pipeline, which drew national and international attention. Okay, so we have a nation comprised of multiple sovereign governments: federal government, 50 states, Puerto Rico, DC, and 573 federally recognized Indian tribes. So how do all of these sovereigns share power? There are exclusively federal powers that are enumerated in the U.S. Constitution, including foreign affairs, immigration, running the postal system, and bankruptcy, which most people don't actually realize is a federal issue. There are also concurrent powers, such as taxation, road work, controlling banks, and criminal punishment. So according to the U.S. Constitution, powers not assigned to the feds are left to the states, and thus we've got some exclusively state powers like education, licensing, and police powers. Those were supposedly exclusive state powers. They're not so exclusive any longer. We do have a lot of overlap and oversight. So for overlap, the same action might constitute both a state and federal crime, and the defendant might have to stand trial in both a state court and a federal court and be punished by both. For oversight, we've got agencies like the National Institutes of Health, NIH, and the CDC, and those provide assistance to states, but they also make sure that states have enacted certain plans, including emergency response plans, as required by federal law. So at the federal level, Congress has to have constitutional authority to pass laws. So this is why, if you look through the notes section of various statutes, which we will get into next week, you'll find references to parts of the Constitution. This is Congress's way of showing that it is operating under properly granted authority. When the U.S. Tea Party movement first sprang into existence back in 2009, I think, members of the Tea Party talked a lot about how Congress is never telling the American people why it had the authority to pass laws. That allegation was simply untrue because Congress has always been required to explain its authority, and Congress does so in every piece of legislation. It's just that most people don't know where to look for that information. You will be amongst the group of people who do know where to look for that information after next week. Because any time that Congress passes a law, it has to do so pursuant to its constitutional authority. And there are three main grants of authority: the Necessary and Proper Clause, the Supremacy Clause, and the Commerce Clause. For a long time, Congress was able to rely on that third one, the Commerce Clause, as the source of its authority for a lot of sweeping laws. And it still does, but that claim is under more scrutiny now than it had been in the past. So the reason why we even have a Commerce Clause is because when our government began, the federal government was much, much weaker than it is today. So prior to the Constitution, we had the Articles of Confederation, and those articles specifically created a weak national government and strong state governments. This did not, however, work in practice. It quickly became recognized that we needed a stronger federal government. So the Constitution included the Commerce Clause, which has been the major source of Congress's lawmaking authority throughout American history, and most especially since the New Deal. And the New Deal was a series of programs, public work projects, financial reforms, and other regulations enacted by President Franklin D. Roosevelt in the 1930s. And the intent of the New Deal was to provide relief, reform, and recovery from the Great Depression. The Constitution also contains the Necessary and Proper Clause, which states that Congress can enact all laws that are necessary and proper to carry out the powers granted to it by the Constitution. And it also includes the Supremacy Clause, which states that the Constitution is the ultimate law of the land and that federal law is superior to state laws. So in part because of the Supremacy Clause, as the federal government has grown, the powers granted to Congress by the Supremacy Clause and also by the Necessary and Proper Clause have moved our country to a more hierarchical federalist system. There are additional constitutional amendments that give Congress powers beyond what was originally in the Constitution, such as the enforcement of federal civil rights laws, which we will discuss later in the semester. So the federal government has been growing since the start of our nation, but that growth has rapidly increased since the start of the 20th century. And a lot of that growth relied on the Commerce Clause. So particularly after the Great Depression and World War II, President Roosevelt relied heavily on the Commerce Clause. I say President Roosevelt, but also Congress, relied heavily on the Commerce Clause to revive the economy and handle sort of newly arising social issues. And the New Deal itself created many of the federal agencies that we take for granted today. The emergence of a national marketplace as we were able to, start traveling across our country, because keep in mind, we are an enormous country, and that's something that Europeans don't experience. But having this national marketplace emerge, and then having a global marketplace emerge, that also led to the growth of the federal government. Because as people became more interdependent on each other for food, healthcare, technology, and other aspects of life throughout the 20th century and now into the 21st, the bureaucratic infrastructure expanded as we leaned on the federal government to provide assurances of safety, privacy, and quality. After the terrorist attacks on September 11th, 2001, we saw another rapid growth in the federal bureaucracy. The George W. Bush administration drastically expanded the bureaucracy by creating the Department of Homeland Security, and President Bush oversaw the largest federal reorganization in U.S. history as it moved agencies around and put a lot of them under DHS. So again, we can see here that the federal bureaucracy is not intended to be partisan. So while conservatives generally advocate for smaller government, Republican presidents have expanded the federal bureaucracy whenever they deem it necessary, whether that be the creation of the EPA by President Nixon to address environmental issues, or the creation of Homeland Security by President Bush to address the need for better agency cooperation in managing national security and emergency preparedness. All right, let's talk briefly about the history of the Commerce Clause, given its importance to our bureaucracy. So Congress for a long time used the Commerce Clause to pass basically any law that it wanted to. So the reason that we have the Commerce Clause is, again, prior to the Constitution, when our country was operating under the Articles of Confederation, states wanted to protect their own citizens, and they tended to discriminate against citizens and businesses of other states. So under the Articles of Confederation, our country was operating more like many, many countries, little nation states, rather than one united country. So for instance, Massachusetts could impose a 50% tax on goods coming from New York because the state of Massachusetts preferred that its residents support Massachusetts businesses. That was pretty widespread, and the Commerce Clause put an end to that type of state-to-state discrimination, and it allowed for a better flow of commerce across the nation. Much later, in the 1960s, the Commerce Clause served as the basis for almost all of our civil rights laws. It really began to gain steam under Roosevelt's New Deal because we needed a lot more federal authority to counteract economic devastation and other problems caused by the First and Second World Wars. And the Commerce Clause did us a lot of good, but Congress would often just make a blithe reference to the clause and didn't really think about whether the law it was passing truly did impact interstate commerce. So nearly 30 years ago, the pendulum started swinging back to limit Congress's authority to use the Commerce Clause. So in the past few decades, courts have been scrutinizing Congress's claim of Commerce Clause authority and requiring Congress to show an actual impact on interstate commerce, not just a theoretical impact. So in order to really understand the Commerce Clause, we have to understand what counts as interstate commerce. So clearly that's commerce between two or more states, but it's broader than that because the Commerce Clause allows Congress to regulate the channels and the instrumentalities of interstate commerce. So channels of interstate commerce include things like navigable waterways, airspace, highways, railroad tracks, telephone lines, and even the internet, because these are the conduits through which interstate commerce travels. Instrumentalities of interstate commerce are the means used to transport goods and persons. So that would include railroad cars, buses, trucks, planes, boats. The line between a channel and an instrumentality is actually somewhat unclear, but that really doesn't matter because when it comes to court cases, the analysis is the same. So there are limits on the Commerce Clause, and those limits usually deal with the difference between an issue that is truly national or interstate and one that is truly local or intrastate. So if it is truly a national issue, Congress can legislate and pretty much force the states to do its bidding. But if the issue is truly local, Congress cannot order the states around. So that pendulum of Commerce Clause jurisprudence began to swing back towards the states in 1992 with the case of City of New York versus the US. And that was about how the government disposes of radioactive waste. So in that case, the federal government attempted to force New York City to carry out a federal radioactive waste disposal program. And New York City was not too keen on the idea of babysitting tons of radioactive waste, so it sued the federal government. And in that case, the Supreme Court agreed that the feds cannot force states to carry out federal programs when all of the activity was occurring within a single state's borders. Similarly, in 1995, in U.S. v. Lopez, the Supreme Court struck down the Gun-Free School Zones Act. Now, this wasn't because the court wanted school kids to be packing heat. It was because Congress didn't provide a sufficient reason as to why it was authorized to legislate the activities of public schools, which are local or state government bodies. So in that case, the Gun-Free School Zones Act, Congress claimed that the possession of a gun in a public school would likely lead to violent crime, and any uptick in violent crime would affect the nation's economy by raising insurance costs and by making people scared to travel to or through unsafe areas, and thus people wouldn't spend as much money in those areas. But the Supreme Court did not buy that argument with regard to congressional authority. So research has shown that yes, violent crime does impact the economics of the surrounding area, but the court held that gun violence does not impact interstate commerce, and so Congress couldn't use the Commerce Clause to essentially regulate state and local school systems, which are the provenance of state and local governments. The Supreme Court continued to limit Congress's power under the Commerce Clause right up till the turn of the new century. For instance, it struck down requirements of the Brady Bill, which was passed after then White House Press Secretary James Brady was shot and wounded during the attempted assassination of President Reagan in 1981. Then, for example, in Prince versus United States, the court ruled that state and local police could not be forced to carry out federal background checks. Again, Congress cannot press state and local police into federal service. In 2000, in the case of U.S. v. Morrison, the court invalidated part of the Violence Against Women Act. Again, not because the court encouraged violence against women, but it ruled that Congress cannot regulate, or does not have the authority to regulate, non-economic violent criminal conduct. At least it cannot regulate them based on the Commerce Clause, because regulating violent crime is a police power, and that is generally left to the states. Now, if violent crime is in part economic, and if criminals operate in multiple states, then the feds can indeed be involved. And this is why federal agents are often the ones to bring down, for instance, mafia bosses. Now, keep in mind that Congress often gets around these restrictions by attaching conditions to appropriations rather than relying on the Commerce Clause. So for instance, states have to keep the drinking age at 21 in order to receive highway funds. So if Congress can't use the Commerce Clause to get its way, it can often use the power of the purse. Now, recently, there has been some expansion of federal power via the Commerce Clause for activities that do impact interstate commerce, albeit not obviously. There was one particularly odd instance involving the regulation of kitty cats, where the court found that descendants of Ernest Hemingway's six-toed cat named Snowball, the descendants of that cat live in his museum home in Florida, and they are subject to federal regulation because the court found that those cats substantially affect interstate commerce. And that's because the Hemingway Museum, located in Florida, advertises its six-toed cats as a reason for out-of-state residents to visit Florida. So there came a point when a museum visitor thought that the museum was not treating the cats appropriately, and it filed a complaint with the USDA over the treatment of the cats. Because remember, the USDA, in addition to agriculture, also sort of polices human abuse of animals. So this became a federal case, and the court ruled that yes, the USDA can regulate cats in the Hemingway home and museum because they're used to drum up interstate commerce by bringing tourists from other states into Florida. Next week, you're going to brief a case called PETPO versus Fish and Wildlife Services, which is a Commerce Clause case dealing with Endangered Species Act regulations that protect purely intrastate species. Okay, I do want to talk about a constitutional principle derived from the Supremacy Clause, which is important particularly in environmental law and all hazards management, and that is the federal preemption doctrine. So remember that sometimes federal and state governments have concurrent jurisdiction over some type of subject matter. Well, the preemption doctrine allows the federal government to exclusively control subject matter that was previously controlled by both the federal government and the state governments. So the preemption doctrine allows the feds to exclude state regulation in a particular area in 3 instances. 1, Congress expressly said so. 2, when a state law is inconsistent with federal law. Or 3, where there is something that we call a comprehensive scheme of regulation. So for instance, the Voting Rights Act of 1965, a federal law, that preempts any voting restrictions in state constitutions. And when Congress regulates an interstate economic activity, when it does so with a comprehensive regulatory scheme, it can also regulate aspects of that activity that are intrastate in nature. Okay, so federalism is the division of power between 2 sovereigns. The doctrine of separation of power is the division of power within a single sovereign. And its intent is to create a system of checks and balances so that no branch of the government can dominate the other branches. So a well-known example is that the courts can review Congress's exercise of authority and determine if Congress overstepped its bounds by striking down the law. Or you've got Congress passing laws, but the president, who heads the executive branch, has to sign those laws before they can take effect. Less well known to the general public is the concept that one branch of government may not exercise the authority granted to another branch. So the president cannot interpret the law to resolve a dispute, say, between a company and an agency. That is left to the judicial branch. And the judicial branch can't create laws. That's left to the legislative branch. We will learn later that the judicial branch does create what we call the common law. But that operates when there is no legislation covering a particular situation. Now, agencies create a unique situation with regard to the concept of separation of powers because they exercise functions of all three branches of government. So as they're part of the executive branch, and agencies exercise the executive function of implementing and enforcing laws, and that makes sense because that is what the executive branch does. But Congress has also delegated agencies some legislative authority and judicial authority. So agencies can create regulations to fill in the gaps left by Congress when it enacts laws. And that is a fairly large part of what agencies do. They create regulations which have the force of law. Congress has also delegated the authority to adjudicate certain cases, which is a judicial function. Now, Congress, of course, retains the bulk of its legislative authority, and it can basically veto agency actions as long as they do it the right way. So, for example, there was a case, INS versus Chadha, where the court struck down the idea that a single house in Congress could overturn an agency regulation. So to clarify its ability to address agency regulations with which it disagrees, Congress then passed the Congressional Review Act, and that specifically allows Congress to review and overturn agency regulations as long as it does so with votes in both the House and Senate, and also within a certain amount of time after the regulation was issued. So Congress does have to move quickly to use the Congressional Review Act if it does not like an agency regulation. And because of the unique role of agencies, we should be concerned about the lack of separation of powers within agencies, because the absence of this doctrine can leave agencies without effective oversight. And this is especially true if they're independent agencies. And at the same time, it can increase agencies' independence and it can decrease agency accountability. So separation of powers within agencies is a big deal. And independent agencies can be even trickier. Independent agencies are sometimes called the headless fourth branch of the U.S. government. And that phrase comes from a court decision, PHH versus the Consumer Financial Protection Bureau. So typically, the president has the constitutional authority to order about subordinate officers in the executive branch, and that includes cabinet secretaries and agency heads. And the president can even fire a lot of those officers at will. It is a different story, though, when Congress creates independent agencies. These agencies are still technically within the executive branch, but the president has to have cause to remove an agency head. So this puts a bit of a buffer between the agency and the president, allowing the agency to operate more independently. But, of course, this creates an even bigger separation of powers problem, because independent agencies are still exercising the functions of all three branches of government, but they're not directly accountable to the president. And because they're not directly accountable to the president, they're not accountable to the people. So because of this amount of independent power that they wield, independent agencies are usually headed by multiple commissioners or directors who can act as checks on each other. So they don't necessarily have a single agency head or administrator. And this multi-member structure does reduce the risk of arbitrary decision-making and abuses of power, so it helps protect our individual liberties from agency overstep. So in that PHH case, the DC District Court that decided the case stated that, quote, the president executes the laws with the assistance of subordinate executive officers who are appointed by the president, often with the advice and consent of the Senate. To carry out the executive power and be accountable for the exercise of that power, the president must be able to control subordinate officers in executive agencies. So that is kind of a long-winded way of saying what most of us already know. To be the boss, you've got to be able to control your employees. But it is not that simple when it comes to our federal agencies. So Article 2, Section 2 of the Constitution plays a major role in the appointment of agency personnel. So agency heads are superior officers, and they are nominated by the president with the advice and consent of the Senate. Other agency personnel could be inferior officers or simply employees. And Congress gets to decide how to appoint inferior officers, and it can delegate that responsibility to the president, to a department head, or to a court. Because of the unique method by which they're created, so Congress creates an agency and then places it in the executive branch, and because agencies are, for the most part, intentionally removed from politics, they remain somewhat exempt from the president's control. Now, even if they were not created by Congress, even if they didn't have their powers and budgets defined by Congress, it would still be very challenging for the president to directly control the federal bureaucracy because of its sheer size. So the president does establish policies for administrative agencies, such as via an executive order, but the president's control over executive branch agencies is definitely not as simple as, say, a CEA's control over her division chiefs. It's Congress that actually has the greatest control over agencies. Congress creates them, reorganizes them, dissolves them. Congress is the one that establishes the budget for each agency. By passing statutes that tell agencies what to do, Congress sets policy objectives for agencies, and it engages in oversight of agencies via various congressional committees. For a long time, however, political and practical reasons kept Congress from flexing its muscles and exercising control over agencies. And part of this is because politically, members of Congress like to insulate themselves from criticism by pointing instead to agency officials. So the idea was that for unpopular regulations and unpopular policies, the buck didn't stop with Congress. Congress happily passed it like a hot potato to the agency. In part, because of the partisanship that has consumed Washington for a while now, Congress has occasionally become more willing to control agencies. So in the case of the Consumer Financial Protection Bureau, which was created during the Obama administration, the GOP-controlled Congress wanted to weaken that agency. And so it insisted that Congress control the CFPB's funding. Now, this is actually really rare because in the history of the United States, no banking regulator had been funded through Congress. Regulatory agencies instead covered costs directly or indirectly through banking fees, and that was in order to keep the regulators safe from political pressure. But controlling funding is definitely a good way for Congress to control agencies, and Congress can use that to weaken an agency's powers of oversight. Congress can also weaken an agency by limiting its duties, and it did this with the Troubled Asset Relief Program, or TARP. So in that case, Congress empowered the oversight panel for TARP only to write reports. It had no ability to subpoena information or take testimony. And Congress can also flex its muscles using the Congressional Review Act, which we are going to talk about shortly in Part 2. So as I noted a couple slides ago, there has been a struggle between Congress and the president when it comes to removing agency officials. In the 1926 Supreme Court case Myers v. United States, the court invalidated a statute that required the president to get the Senate's approval to fire postmasters. So this was generally meant or believed to mean that Congress could not interject itself, because it's a legislative branch, into executive branch functions. In 1935, the Supreme Court decision in Humphrey's Executor versus United States changed this viewpoint to a degree, because there the court upheld a statute that limited the president's ability to remove FTC commissioners by requiring a good cause for removal, rather than the at-will removal that had been permitted by the Myers case. So in Humphrey's Executor, the court clarified that it is the nature of the position subject to removal that is critical. Postmasters are purely executive officials. They carry out laws, but they do not make policies, and they do not perform judicial functions. FTC commissioners, on the other hand, issue regulations and they hear disputes. So the Supreme Court held that Congress could reasonably limit the authority of the president to remove FTC commissioners, but not somebody like a postmaster. In 1988, there was another shift in thinking. In Morrison v. Olson, the Supreme Court upheld a statute that limited the authority of a president to remove a purely executive official, in this case, the independent counsel. So here, the Attorney General, who is an executive officer, was able to remove the independent counsel, and the president was able to remove the Attorney General. So this has shifted our focus from the type of functions an official is performing, executive, legislative, or judicial, to whether Congress has impaired the ability of a president to perform constitutional executive functions, and whether Congress has improperly delegated those executive functions to itself. And this struggle continues. In the 2010 case of Free Enterprise Fund versus the Public Corporation Accounting Oversight Board, the court held that the method through which members of that board, which supervises compliance with the Sarbanes-Oxley Act, are removed, violated the Constitution's separation of powers. So board officials could be removed only for good cause shown by officers of the Securities and Exchange Commission. And officers of the Securities and Exchange Commission could be removed by the president for good cause. So this created what the court called a dual for-cause limitation. And this meant that the president was restricted in his ability to remove a superior officer, who was in turn restricted in her ability to remove an inferior officer, even though that inferior officer determined policy and enforced the laws of the United States. And that violated the Constitution's separation of powers doctrine. Okay, so where are we now in terms of agency oversight and control? For decades, presidents had the desire, but not the authority, to control agencies. This has changed rather drastically and suddenly with the Trump administration, because President Trump has tried to exert, and frequently has exerted, a lot more control over the bureaucracy by appointing and removing agency heads, and also by relying on interim agency heads who do not require Senate confirmation. But agency civil servants, the career people, they have tried hard to dodge presidential control under all presidents, not just our current one. And it's not that the civil service abhors presidential control, it's that public administration policies take a long time to implement. And public administrators kind of want to focus on the long game and not the shifting winds of politics. So unlike presidents, Congress has always had the authority, but not the desire to control agencies. So historically, Congress has relinquished its oversight in favor of waiting for judicial review. So basically, Congress punts to the courts. But keep in mind, judicial review takes years, and we will talk about that later this semester. Now lately, at least some members of Congress do seem fairly interested in dismantling the bureaucracy, even though unfortunately, many of those members of Congress have no real idea of what the bureaucracy does for the nation, let alone the critical importance it plays for American people, especially in rural areas. But thanks to the internet and social media, we are seeing the public becoming more engaged in agency oversight. But again, members of the public, regardless of political affiliation, rarely understand just how much the bureaucracy does for Americans. So even though we don't necessarily understand it, we do expect a lot from our government. We want the government to address social issues like data privacy, race, gender, age, disability. We want the government to provide services and benefits. We want first responders to show up when we need them. We want sanitation workers to take care of our waste. We want access to national parks. We want our highways to be properly maintained. We want the government to oversee economic issues, at least to a certain extent. Regulation of markets, economic developments, we want that sort of thing from our government. And we expect our government to regulate environmental issues. We want clean water and clean air, but we also want cheap and plentiful energy. So in general, again, regardless of politics, the American people do expect quite a lot from our government. And today our government at the federal level consists of 15 cabinet-level departments, each run by a secretary, plus a number of departments with the same status of a cabinet-level department, but without a secretary, such as the EPA and NASA, which are headed by administrators. And together, the federal government has about 4 million direct employees. About 1.4 million of those are military personnel. We rarely think of military personnel as agency employees, but they are in fact employed by the DoD, which is an executive branch agency. So in addition to its direct personnel, the federal government has a ton of indirect personnel. We don't actually know how many. Our best guess is around 14 million people. And so these include personnel at quasi-official agencies like the Smithsonian, quasi-governmental agencies, but also government contractors and grantees. And we're going to talk about them later this semester. So here's the list of our 15 cabinet-level departments, all of which contain numerous agencies within them. And those agencies might be called agencies, boards, bureaus, commissions, or some other name. And this list on the screen also includes some of the independent agencies. So when you start thinking about the topic you want to select for your policy analysis memo, remember that you've got to focus on an agency and use this list to get started when it comes to federal agencies. You can also, of course, write about state and local agencies. Okay, next up, please watch part 2 of the lecture, which is about agency discretion.